Hello, Ms. Nelson, can you hear us?
I'll turn my speaker off. Hold on. It's off. I think it was.
Try again.
Where's it coming out of? No, it's
coming out of the. It sounds like it's coming out of that connection.
I am now unmuted.
Okay, now I unmute. Can you hear me? But I can't hear anyone else.
I can hear you, Ms. Nelson. This is Marshall Hodge.
Okay, now I can hear you. Okay.
Ms. Nelson, can you hear me?
Yes, I can.
But we get that echo. All right, we're still not on the record, but hopefully now Ms. Hodge, Ms. Crawford, Ms. Rolak, Ms. Nelson can all hear me. If you can hear me, raise your hand. Great, all right. And Ms. Nelson, I'm pretending you're raising your hand, but I know you can hear me. There's Ms. Rolak, excellent. We are going to get started in a moment. Your audio feed will come through the computer on my desk. The court reporter can hear that. If folks in the larger courtroom cannot, I may repeat what you say, so it may be a two-step process. We're working on ironing out the details. This is why we're having a test run of just a few defendants, and we'll see how it goes. We'll try to smooth things out, but thank you for bearing with us as we take care of this. All right, Ms. Snyder, are you ready to go? Do you need to talk with Mr. Holt before?
No, I'm ready now.
Okay, and then I guess Mr. Franklin and Mr. Lyres are meeting with Mr. Reyes Hernandez right now. You've had a chance to talk with Mr. Brown?
Yes.
Okay, then Mr. Franklin has the other gentleman on the calendar. The last two positions are one person, but we can deal with that when we've handled the other three. So I think we'll get on the record in just a moment and get going. Any technical questions, procedural questions before we get started? So far, so good. Okay, great. Well, only 23 minutes after we were supposed to start. That's not bad. And I should have asked, Deputy, we have all four. You said that already. We got all four. It's 5 cases, but 4 defendants, and they're all up. So we're good to go from the sheriff's side. Excellent. Thank you. Okay. Well, this is our Tuesday morning inquiry calendar. And we have 4 defendants, 5 cases. We're going to start with position 1, which is Mr. Holt. Before Mr. Holt comes out, Ms. Snyder, tell me what we're doing with Mr. Holt's situation.
Your Honor, Mr. Holt's case went to trial and then was reversed on appeal and remanded back to us. We got it on arraignment right before the first judicial order came down. So I know that there was a scheduling order issued, but then we got all the orders told and all the deadlines.
So we should talk scheduling.
Right.
Okay.
I don't have the digital discovery. I just have what I was able to print off of Odyssey. And I think I'm missing the motion for new trial transcript, but it may be in there somewhere that I missed.
Okay, I'm getting it on Odyssey now. And let's see.
The appellate attorney was able to forward me the trial transcripts, but I don't know that she sent me the motion for new trial.
There was one file that was denied. Was there another file before the appeal came in?
What?
Was there another motion for the trial file? Oh.
No, I didn't have the transcript of the hearing where it was denied. And then
Yeah, it's here. I can email it to you, but it's a docket entry of June 2018, motion for new trial transcript from April 11th, 2018. So you should be able to find it, but June 26th is the docket entry for the transcript. Okay, well, let's get Mr. Holt out here. We'll talk a little bit about where we might go next. Thank you. Do we need to get Mr. Franklin and Mr. Lyres out, or can they stay back there while Mr. Holt is here? Okay, and before you bring Mr. Holt out, let's talk about the seating logistics. I think it makes sense to have only one attorney at the defense table while a defendant is out here, so that attorney can be at one end, and I think it's going to be the podium end of things. But I'm asking the deputies, I assume you would prefer to bring the defendant as little out of the holding cells as possible. In other words, to the end of the table, closer to the door. Is that right? As between the 2 corners?
Yes.
Okay, so then we'll have defense counsel being closer to the podium, and we'll cycle them out as we're changing defendants. And so the defendant will sit basically in that empty seat right there. If at any time an attorney needs to confer with the client in a way you don't want us to hear it, I think the reality is we got to get you back in lockup, but we'll do that. The shuffling back and forth is.
I can see him after we come out and let him know what's going on.
Okay. Okay, great. All right, thank you. So let's bring Mr. Holt out and we'll try having him right there. And we're just gonna take all of these down. Carl, later I may get a sense that some of these are more just, hey, how you doing? And that doesn't need to be taken down. But for now, let's just, if you don't mind. Okay. You want me to turn this on? Yes, they should have it on. Yeah, because we're not pushing through their system.
This should be on or off.
If you'd like it on, it's easy to have it on. It's not gonna, I don't think it will create any issue. Ms. Snyder, would you turn the microphone on your table on, please?
Just want to test and make sure it's not like positive. It doesn't sound like it.
Okay,
Thank you.
great. We'll turn it off if there is an issue. Okay, this is position 1 on our inquiry calendar, State versus Mr. Holt. Good morning, Mr. Holt. I'm Judge McBurney. We brought you over today. We haven't been able to bring folks from Rice Street over in a while to, and this is actually the first day we're doing it since things got complicated. We need to talk about your case and where it's going. Ms. Snyder, your lawyer, was giving me an update. Apparently, you had a trial and you were convicted, but that conviction was reversed because of some mistakes that the trial judge made in terms of letting in evidence of the alleged victim in the case, what they call good character evidence about the person you are alleged to have robbed. So we are back, not quite at the starting gates. You've already been arraigned and there have been some motions in connection with your case, and that doesn't change, but the trial was undone. So you continue to enjoy the presumption of innocence. And it may be that you and your lawyer negotiate a resolution. It may be that you want another trial. That's something that you and Ms. Snyder will work out. What I wanted to do today was to make sure Ms. Snyder is getting what she's entitled to make an informed decision with you about what's the right next step. You have a somewhat unique perspective in that you've already had a trial, and you might have a feeling of what would happen if there was a second trial. And that may make it easier to think about, do I want to work the case out, meaning enter a plea, or do I want to have a trial again? And I don't get in the middle of that. I will handle whatever it is you and Ms. Snyder decide to do. But Ms. Snyder's going to talk to me, with you listening, about where she thinks she is in terms of getting all the discovery and being in a position to advise you what she thinks you should do, and then let me know, is it going to be a trial or is it going to be resolved some way short of a trial? Does that make sense? Okay, great. So Ms. Snyder, there was a trial, so you should have a transcript of the trial, give you a pretty good sense of what the state's evidence is and isn't, and in particular, what should not come in if there is a retrial. Tell me what you think the right next steps are. And before you answer, there is a scheduling order that is now out of date. It was entered maybe the day or two before the courthouse shut down, and we weren't able to bring people like Mr. Holt over here. So consider those dates redoable. Tell me what you think ought to happen next, and then we'll hear from Ms. Hall, who is prosecuting the case.
Well, I'm still missing the digital discovery. I don't believe there's any fault in this all. I think, you know, the office shut down and she didn't have the file with her and I know it get it to me. But now that things are running back up, they should have the complete file, so it shouldn't be complicated to get it to me and I can make a more informed decision. The trial transcript is quite lengthy. I'm still working my way through it.
Okay. The digital discovery, who represented Mr. Holt at trial?
The public defender's office.
Okay.
There is a point of ineffective assistance, and that's how I got into it.
Okay, so it's not intra-office, it's inter-office, and you have not been able to get the digital discovery from your predecessor?
Not from the public defender's office, and then his appellate attorney, she sent me what she had, but it wasn't any of the digital discovery. It was basically just the trial transcripts and some little things that she had. Because once they close the case, they send it off to their admin, and who knows where it ends.
Okay, fair enough. So you would like the digital discovery. We talked about the motion for new trial transcript. I think you'll be able to get your hands on that as early as today. Anything else?
I don't think so.
Okay.
Once I get the motion for new trial transcript. And I've had previous conversations with Mr. Holt that I don't know about a resolution, but you know, we can still discuss that.
So I'm just looking at the verdict form. One count is gone. The burglary count, there was a not guilty.
There were two counts that there was not guilty on the burglary and then the possession of a firearm by first information or was null prior to trial.
Okay, so still kicking are the more serious charges: armed robbery, aggravated battery, and then an aggravated assault with a deadly weapon and one gun charge. Okay, so there are meaningful counts that would need to be resolved. I was just looking to see if there were any motions that were argued, make sure if there are rulings. Okay, there was some decision about excluding a jail call because it wasn't timely provided. I'm guessing that won't be a defense to the jail call anymore. Okay, that's the only motion. Oh, there was a motion to suppress identification.
That's part of what I'm missing, the photo lineup.
Okay, and that might be in digital discovery. Okay.
There is a version of the lineup in the packet that's filed on Odyssey, but it's a copy of a copy of a copy, and it's completely illegible.
Okay, I don't see an order resolving the motion to suppress identification or a transcript from the hearing. Maybe it's in the trial transcript. Maybe it was something that was dealt with during the trial, but we can work through that if we need to. So digital discovery, and then you ought to be in a position to know, are there new and different motions that you'd want to file? Okay, anything else? Okay, there's a gentleman who's been waiting there. So there was two, oh, there are two files. Are there two files here? There's
No,
supposed to
there's probably only one, Judge. I think that there's another one maybe in the office.
Do you think that one we may have in the office? This is for Garrett Anderson.
Right. I think that maybe actually it might be with Judge LaGrua. That was before it was transferred to us. So I'm not sure where the file is. I'm not sure.
Okay, all right. Thank you, sir.
Thanks,
We've got
Robert.
one of them. Ms. Nelson says thank you also. Sorry about that, Ms. Snyder. Didn't mean to leave you standing there. Anything else on Mr. Holt? I'm going to hear from Ms. Hall in a minute.
Not at this time.
Okay. So Ms. Hall, you're in the office today. What steps do you need to take to get the digital discovery? I'm assuming that's a disk or a thumb drive available to Ms. Snyder.
Yes, Your Honor. This morning I was able to retrieve the file from my record room, and it has all of the digital evidence that whoever my predecessor was able to get. So I will copy those myself. I make it to this 3, I think it's about 5.
Okay.
And so I will turn it over today if I can turn it over personally or however I do it to Ms. Mary Beth. But I also want to ask if I can have time to look at the file completely to see if there's anything else like the jail file you mentioned that were excluded, to see if I need to add anything additional to this file. if we
Sure.
Proceed to a trial. The last time we were in court before COVID, I did make an offer to the defendant in case he didn't want to move forward with another trial. And I don't know where we're at with that. So in case we do move forward with trial, I do want time to be able to get additional discovery if there's anything additional that I need.
Okay. So it sounds like if I'd like to get a new scheduling order in place so we just have some sense of where it's going. If you had 2 weeks to, how much time? The digital stuff you'll be able to do this week.
Right.
Sounds like not a problem. How much time do you want to go through the file to see if there's anything else?
2 weeks is fine. I'll probably get with Ms. McCauley and see if there's anything else that we left out. Other than that, it's probably all ready for trial. I just want to make sure.
Okay, so if we had discovery due by July 3rd, that's a little more than 2 weeks. That's 3 Fridays from now. If discovery needed to be complete by July 3rd, how much time would you want to file any motions that you might file, Ms. Snyder? Knowing that you'll get that digital discovery well before July 3rd. It's just there may be some things that trickle in, like a jail call or something.
If there's nothing new other than jail calls, I think I could use, within that 2 weeks, maybe like the week, Monday after 4th of July. And I think the courthouse actually closed on the 3rd for 4th of July.
Okay, so I don't mean to pick a date so you're thinking that could complicate things because
It's a long weekend and I know that people it should be fine.
historically people went out of town for the 4th of July. I'm keeping that date. People can just get it done before then. This is a case where discovery ought to be pretty easy because it already went to trial. So one view would be we should be able to do it in a day, but things are complicated right now. So we'll say July 3rd for discovery. And then my question is simply, how much time do you want to review what you get, most of which you already have, some of which you'll get this week, to say I have motions, I don't have motions. Okay, well, why don't we say by July 15th, you will let Ms. Nelson know. That'll just be the deadline for filing motions. So if there are no motions filed by July 15th, we'll know that there might be pretrial motions if there's going to be a trial, like keep out a jail call or something, but there won't be a whole nother suppress ID, that kind of thing. And then Ms. Nelson can identify a final plea date to put this case on. So we would next see you, Mr. Holt, either because there's a motion that we need to argue, like trying to suppress something, although I think that's already been argued, or we would next see you for an opportunity for you to enter a plea where you would have the ability to withdraw your plea if the sentence I gave you was more than what your lawyer asked for. That's I'll ask you a question in a minute, but that's probably the next stop. You can always enter a plea after that, but the difference is on the final plea date, if you don't like your sentence, if it's different from what Ms. Snyder asked for, you can back out, no questions asked, that can't be used against you or anything like that. In the future, after that date, you might think, I don't want to go to trial, and you can still enter a plea, but if you don't like your sentence, It's your sentence. Sort of like after trial, you don't get it back out of your sentence. You get whatever your sentence is. Do you have a question about that? You guys will talk about bond, and then if I think it's appropriate to have a bond hearing, we can have a bond hearing. So it's a great question. Yeah. So the way it'll work is that Ms. Hall is going to learn more about the case. She was not the prosecutor, so she's going to read more about it. She knows that there was at least one issue during the trial because it got reversed, but it was more a mistake the judge made as opposed to the higher court saying, oh, it's a bad case against Mr. Holt. Your lawyer is going to be thinking about what to do, knowing that a jury convicted you, but maybe it was only because of that evidence that next time is not going to come in. And so maybe there's a reason to argue for a real lenient plea. But these two people will have the back and forth about what the situation is, and Ms. Snyder will keep you posted. You will not be kept in the dark. You won't come to court and be told, you know, hey, you need to work this out today or else. That's not how it works. So Ms. Snyder will be in touch with you, talk about bond, and also to get your thoughts about what is a reasonable outcome of the case. You guys may not agree entirely. I mean, you may think reasonable is state should dismiss the case. And Ms. Snyder may say, look, I read the transcript and I'm making this up, but your fingerprints are on the gun or something like that. State's not going to dismiss a case if your fingerprints are on the gun. So there will be discussions about that. The good news is we're trying to get those discussions moving again. There's been this block of 3 months where nothing has been happening. And you've been wondering what's cooking. So that's what we're going to do. We're going to get the last of discovery to your lawyer so she can look at it. She can share it with you. And then you heard Ms. Hall, she's going to be talking with her supervisor to see maybe there is a way to work this out. And if there is, we'll bring you back here and take that plea. If there's not, we'll have to figure out when we can do a trial. So July 3rd, discovery is complete. July 15th, motions are filed, and Ms. Nelson will figure out a date for a final plea date, and I'll get that scheduling order entered. It'll be the revised scheduling order for this case. And I think that's where we are. But you raised a good point, Mr. Holt. The other reason why I may see you soon would be to talk about bond. So it could be if there's a motion, like a motion to suppress, it'll be this final plea date, see if the case is working out or not. But there also could be a time when we bring you back to talk about bond. It could be. You and your lawyer will talk about that. And we need to see where the final plea date is too. If the final plea date's in 4 weeks, I don't know that bond would necessarily happen before then, but we'll see. So you and Ms. Snyder will talk about that. Ms. Hall, anything else in Mr. Holt's case? Let me see. Ms. Nelson, do you have any questions about Mr. Holt's situation?
No, Judge, I'm okay.
Great. Ms. Snyder, anything else? Okay. Well, then let Ms. Nelson know, Ms. Snyder, if there are any issues with discovery, and then she'll be watching that July 15th deadline. All right. Good to see you, Mr. Holt. So Mr. Franklin, we're going to bring Mr. Reyes Hernandez out next. Is it just to on the record waive arraignment? Do you not want to bring him out? What is your? Okay. Got it. And we got, okay. Well, why don't we, I don't want to keep Mr. Laris here longer than he needs to be here. So. Okay. All right. So we'll get you out of here well before 2. And thank you, Mr. Franklin. It's good to take care of the initial interview while you have Mr. Laris here. So we'll make that happen. So I'm gonna give Ms. Snyder a couple minutes with Mr. Holt, but not too much longer. And then we'll bring Mr. Reyes out here. Ms. Patel, what are we doing with Mr. Brown?
to re-indict it. I would like to be heard on bond. My understanding is that Ms. Hodge is going to oppose that. If she does, I'm more than happy to file an order to have her to.
Okay, well, why don't, if you can come up to the space right there, I'll engage Ms. Hodge. You'll be able to hear her, and we'll see her thoughts. She may just want time to get someone plugged in, and then we can certainly either get Mr. Brown back here or get it on one of our Zoom calendars if he's willing to waive being physically here. Otherwise, I guess technically he needs to be arraigned, but it's sort of a futile exercise if there's going to be a new indictment.
I didn't even think of that. I filled out the waiver for arraignment.
But you should. I think that's good.
And then if they re-indict it,
Okay.
And Your Honor, this will be Ms. Hodges' case, but I'll have to proceed today.
Okay. And then Mr. Franklin, with Mr. Anderson with 2 cases, what are we doing? Do you haven't had a chance to talk to him, or you know what's happening with him? To both cases. All right.
It's the same set of circumstances, it's just that 2 charges were kind of added on later.
Oh, okay. Like,
Two charges were added,
got it. Okay, great. Then Ms. Patel, why don't you come up a little bit? Ms. Hodge, can you hear me?
I can hear you, but I couldn't hear Ms. Patel.
I'm having her come closer, and I'll rotate this. You're not gonna be able to see her or me, I think, but you may be able to hear Ms. Patel. You can be in that little, it's up to you how close you want to get, but you can be right there. Can you, why don't you say something?
Ms. Hodge, I just made the announcement that this is being moved to CWAC and that you intended to re-indict the case.
All right, stop. Were you able to hear that?
Yes, that CWAC is going to re-indict the case.
And to be clear, we're talking about the James Brown case.
Yes, Your Honor.
Okay, and Ms. Hall announced, so you know, that she's in a position to handle whatever we're going to do with James Brown today. So she's able to assist as well. Ms. Patel explained that she's filled out the waiver of arraignment form on the case ending in 795, but if it's going to be re-indicted, we'll have to repeat that process. And Ms. Patel said she'd like to be heard on bond, meaning the question of bond, and she thought that you or Ms. Hall might have an objection in terms of notice. All I have on the calendar is that we're dealing with arraignment today, and Ms. Patel acknowledged that. So if we need to, set this down for an official bond hearing with notice, we can do that as well. So I just need to know who should be doing the talking for the state. Ms. Hall says she's going to do the talking. You all right with that, Ms. Hodge?
I am, Your Honor.
Okay. All right. Thanks. You don't need to take this part down. Thank you.
Your Honor, for the record, the state will be opposing bond in this case. Originally, I thought this was a case that was assigned to, well, it was assigned to the trial division. That investigates the charges and what happened. I spoke with one of the victims' mother. The victim is a child. I spoke with her mom. She gave me a lot of insight on what actually happened that day. She was not present, but her daughter called her. She was the one who called 911. Apparently there was a gun involved in this case where the defendant pointed that gun at the child's head and was actually strangling her in the bed. Those charges aren't here.
They're not.
I'm not sure why. But apparently this is something that happened, and this is something that happened where the police officers, when they came out, they were looking for the gun. So this was reported at the time. I just don't know what happened with this case. So I did speak with Ms. Hodge, let her to advise that this would be something that would be upgraded to cruelty in the first and aggravated assault strangulation. They will accept the case, so it will be reindicted to cruelty in the first degree. But we will be opposing bond as far as the defendant and the violence with this child and the other children that are siblings to this child. So to give you a background.
Well, I don't need any more background right now.
I'm very confused because my client should be here if this is a bond.
Well, it's not a bond hearing. I just wanted.
I'm sorry, we could have stopped me 10 minutes ago.
That's okay. It wasn't 10 minutes. I was just trying to understand where the case was going. So the reality is it will not be reindicted anytime soon. And that's not because of Ms. Hodge or Ms. Hall or the DA's office. They're not going to be grand jurors anytime soon. We ought to have a bond hearing. It won't be today because it sounds like there may be some alleged victim input, and that's appropriate. And obviously, Mr. Brown should be involved with the bond hearing as well, which is not what we just did. But I now understand why the state believes that ultimately the case will end up as a CWAC case. The fact that it can't move there right away isn't Mr. Brown's problem. So we will have a bond hearing, but the state is asking for notice. And I need to honor that request. So Ms. Patel, if you want to work with Ms. Nelson, you can file the bond motion, but more importantly, get a date with her so that she can push the calendar out. But Ms. Hall and or Ms. Hodge, you should know that the next time Mr. Brown is on a calendar, it will be for purposes of bond. And now that I think about it, it's particularly good that you prepared the waiver of arraignment, because this, I'm going to want to move Mr. Brown's case along, not the final disposition. I'm not pressing that. But we at least ought to make sure you're getting discovery, all the discovery that may shed some light that it was undercharged. That's the state's call. But there still may be procedural things we could take care of, like a suppression motion, and re-indicting the case won't undo that good work that we do. I just know we won't have grand jurors for the foreseeable future. So that's not going to be a reason to delay work on a case unless both sides say, no, we want the dust to settle. And I'm not hearing that from the other side. So I don't think that disadvantages anyone. The facts and circumstances of the situation are something that both sides can talk about. It just may not be reflected at this point in the charges. So I'm not trying to keep Mr. Brown out of here. I just wanted to know what we were doing.
I do have a question for your honor, given your experience with accountability court. I have been interviewed and accepted into Veterans Court, which is what I'm trying to resolve this case as. I didn't know if they will take people that are just on bond waiting for a disposition on their case, because I would, if it's possible for him to start the program while he's out on bond, that would, I don't know if that's possible, or if that's ever been a thing that has occurred.
So that's an interesting question. The typical approach in that setting would be track one, but then the state is backing off, and the state is doing the opposite of backing off right now. It sounds like they're trying to ramp it up to reflect what they think the evidence shows. I think that before I would try to get Mr. Brown in the direction of Veterans Court, I'd want to make sure that the state had shared with Veterans Court whatever's in their file, because I don't know that Veterans Court would have accepted Mr. Brown if there is the type of evidence that we're hearing about. Not because they'd accept it as true, they would just say this isn't, until that gets sorted out, it's not the kind of case that we take. But either way, it couldn't be track one, because the state wouldn't say we're deferring prosecution. And Mr. Brown would need to get a bond first. So Ms. Hodge, we'll get Mr. Brown out here in a little bit, but it's simply going to be a meet and greet, and he's waiving arraignment, and I'll let him know what the likely next steps are. First of which will be a bond hearing. You're welcome to stay on the call, but well, I guess you are handling the Reyes-Hernandez case as well. So you'll be plugged in for both of those. All right, I have a feeling for what we're doing with each of these folks. Can we get Ms. Snyder out, because we need to get Mr. Reyes-Hernandez out? Thank you. Mr. Laris, you should position yourself wherever you're comfortable, as long as you can hear what Mr. Reyes Hernandez is saying. And it may be that you're standing, sorry about that, but I don't think this will be a very long proceeding. He's gonna sit right there. That's his spot. Okay. Thank you, Ms. Snyder. I don't know if you got to finish with Mr. Holt, but we needed to move to the next situation. Okay, all right. Okay, we're gonna turn to position 2 on the inquiry calendar. It is State versus Mateo Reyes Hernandez, indictment 20 SC 174853. Mr. Reyes Hernandez is represented by Mr. Franklin, who's at the podium. Handling the case for the state is Ms. Hodge, who is appearing remotely. I'm going to swear in our interpreter, and then Mr. Franklin, you can let me know what we're going to do today with Mr. Reyes Hernandez's case. Mr. Laris, do you swear or affirm that you will translate to the best of your ability from English to Spanish and Spanish to English? Thank you. Good morning, Mr. Reyes.
Good morning.
Mr. Reyes, the way we're going to work this hearing is that even though you may understand what is said in English, you need to wait until Mr. Laris translates it into Spanish. Okay, and then you can answer English or Spanish, but it's actually Mr. Laris who will be speaking your answer in English for the record. I don't think there'll be many questions, but that's how we'll do it, okay? Okay, Mr. Franklin.
Yes, Judge, we simply entered plead not guilty, and we are waiting for arraignment today. One thing that I have discovered in my conversations with Mr. Hernandez Mateo is that his name was mixed around in the indictment. His legal name is Reyes, his first name, Hernandez hyphen Mateo. So I'm not sure if that's something that we need to address on the re-indictment, but it's probably best to actually add your actual name.
Sure. Okay.
There's a portion of the waiver that actually confirmed his address, but I don't have the notice that was actually sent, so I'm not getting to that portion at this point.
Okay, I can look that up and we'll see if that's still a good address. And I apologize about your name. So, sir, your first name is Reyes?
Yes.
Okay, and then you would be Senor Hernandez.
Yes, it is my last name.
Okay. Mr. Hernandez, it is. So what you were saying, Mr. Franklin, is that you wanted to confirm what address was in the system for Mr. Hernandez, or? Okay. And he didn't provide you with one, or you?
I don't know what the record is. I haven't.
Okay.
We haven't filed a report. I just remember to check it and say it's a ship record.
Got it. So what I have is 613 Eagles Crest Village Lane, 4 words, in Roswell.
Yes, I was detained there.
Is that your residence? Is that your home?
Yes.
at 613?
Yes, it is 613 gate door 12.
Okay. All right, you want the zip code is 30076. Ms. Hodge, I don't know how much of that you were able to hear. We have the correct name for the defendant. First name Reyes, last name Hernandez. So it's Mr. Hernandez. And he has waived arraignment and is entering a plea of not guilty. We should get a scheduling order in place in the case. Are you in a position to get discovery to Mr. Franklin in the next few weeks, or what's a reasonable deadline for gathering up your case file and making it available to Mr. Franklin?
I will certainly try, Your Honor, to get him discovery in the next few weeks.
Well, tell me what, excuse me,
I'm
what a
not sure.
reasonable time frame is.
I don't have the hard copy file in front of me. I only have what's in Odyssey. So if there are interviews or videos, that may take a while. Probably I would ask for a month.
And why would it take, just so I can understand, why would it take a month to let's say in the hard copy file in the DA's office, a few floors away from where we are right now, if there's a DVD with an interview, why would it take a month for that to get?
If I have it, Your Honor, then it's just a matter of burning it and providing him with a copy, which would be a few days. I'm just saying that if we don't have it, I'm not sure how long the agencies are taking to respond to discovery requests at this point.
Got it. So you may look at the file and realize Roswell PD did 4 interviews, and it's clear from a report that they did 4 interviews, but you don't have them. So then the question is, how long does it take to get that from Roswell?
Exactly.
Okay.
Yes.
All right. Were you able to hear all that?
Yes, sir.
Okay. All right. I'll work with Ms. Nelson on getting a scheduling order in place with an eye to giving you more than just a few days to get the discovery together. What would be helpful, I guess, is sooner you or a colleague of yours can look at the physical case file to see what might be missing. The sooner you guys will be able to jump on that. But we'll get a scheduling order out and then let Ms. Nelson know if there are additional court appearances that need to happen. Do you know, Mr. Franklin, if there is a detainer on Mr. Hernandez?
Well, I initially checked, I did not see one,
Okay.
but I haven't checked his booking screen in a few weeks.
Okay. All right. Ms. Hodge, anything that you want to add about Mr. Hernandez's case, other than that you will get to work on discovery?
No, Your Honor.
Okay, thank you. Mr. Hernandez, the prosecutor is going to be providing information about your case to your lawyer. He will share that information as he is able with you. And then you and Mr. Franklin will decide what the right next step is for your case. And we'll bring you back to court to work on whatever that next step is. So if you have questions or concerns, you reach out to Mr. Franklin, okay? Do you have any questions for me at this time? You want to tell Mr. Franklin what the question was? Why don't the 3 of you just talk right there? has it been going in terms of hearing things? Good. And
I can reach over and turn up.
oh, you're hearing the Zoom through your headphones?
I'm hearing the Zoom through your microphone. That microphone I have there.
Yeah.
And through-
Oh, okay. Not just coming out of these. So I can turn these speakers down a little bit.
Yes, if they're going through, if the sound's going through there, you can turn those speakers down.
Okay.
We can try that and see.
I'm not gonna turn it off. I had it a little louder than normal because I want to make sure you could hear it.
If it's coming through those speakers at the bottom of your mouth, I have a little microphone there that's picking up.
And do you think that if I have my mic off, do I need to have it on for those speakers? Those speakers are doing what they're supposed to do, regardless of whether this is on. Okay, great. As long as you can hear, I don't really care the source.
I was talking to you a while ago to see if there's a way I can, that they can plug me into the FTR system if they can. I'll be fine. I'll have to run microphones everywhere.
We're exploring ways to plug into the FTR system. What they're looking for is a single solution for these hybrid hearings. The problem is we've got 3 courtrooms with phenomenal sounds, better sound systems, FTR, and then we've got the rest with the dumpy old ones that are copper wires and electrical tape, and you can't plug into those.
It was a question that I can address when we finish our initial conversation.
Okay.
The other thing that I would add is because this is my initial day of discussing things with them, I likely will consider filing a bond motion a couple weeks back to figure out the container issues.
Sure.
All those things.
Okay. So Ms. Hodge, in case you couldn't hear that, whatever question Mr. Hernandez had was one that was appropriate for his lawyer, and Mr. Franklin and Mr. Hernandez will work through that. Then Mr. Franklin announced that he needs to spend a little more time with the case file, but he may well be filing a motion for bond. That would be a notice motion. So we would schedule a hearing, and if Mr. Hernandez is willing to waive his presence, it could be a Zoom one, or we can have Mr. Hernandez come here if we get these types of calendars up and running. But Mr. Franklin wanted a chance to research the detainer situation, as I suspect you will be doing as well. Ms. Hodge, anything else for the state in Mr. Hernandez's case?
No, Your Honor.
Okay, well, thank you. It's nice to meet you, Mr. Hernandez. We'll see you soon. Yeah, you guys talk. Mr. Brown is next, but I'm going to give them a few minutes to talk. Oh, because I was going to talk to Mr. Lyers, but you need Mr. Lyers back there. You guys go back there and finish up. I'll grab him on the back end. You bet. Ms. Nelson, I have the waiver of arraignment and entry of appearance in Mr. Hernandez's case. What should I do with it?
Can you scan it to me?
Yes.
Thank you.
Okay, I'll do that later today.
Okay. Actually, you can have Monica scan it to me. I think she's in the office, Judge.
Okay, well, if she's there, I'll go bring it back right now because we're giving Mr. Franklin a minute with Mr. Hernandez. Just calling up Mr. Brown's case. So do you have any materials on Mr. Brown's case besides the indictment?
I have a police report, but I don't have anything that would substantiate what the state is indicating.
Okay, I'm not taking side. I was just curious because there's nothing in the docket.
Right. I believe that we received the police report from the previous prosecutor first appearance.
Yeah, I have that. There's a 27-page packet that was the complaint package. So that's probably what you have. Because there's a APD report dated 2/23. Okay. And it's Mr. Brown is Veterans Court, so he was in the military at some point.
Yes.
Okay. I'll be right back. How are things going in terms of moving people around? Good. Did you know if did they come over on the vans or a bus?
That's a good question. I don't know how that came over.
Okay.
Most likely the parents, this is only, I think the total of 6 or something like that.
So it's 5, it's 4 here. There are others in the building?
I believe so, that's the number wrong. I know we have 4. But I thought the board this morning, it was a total of 6.
Who else got brought over? All right, because we'll when we're done, I'd love to hear from you and your colleague how it went. And then I'll talk with Colonel Jones and Colonel Moffitt, see if there were any hiccups, if we need to do things differently. And then we'll try out next Tuesday with 2 judges.
Okay.
Great. So do they even go to the tanks down in the basement, or did they come from the vans straight here?
They went to the tanks and basement.
Okay, so it was a 2-step. However they got here, then they went to the big tanks, and then you guys got them up from the big tanks to here.
Yes.
Okay, great, thanks.
No, period.
I don't know how we can do this with more than 6 people a day.
You know, we crazy. Like, did you come through when we had to do the heat thing? Is that on both sides?
Oh, the temperature, and then it kind of was like 92 degrees. I would be dead if I was in my body to 92.
Then they stopped me, and I was like, because we were doing that last week when I came here. But that's gonna really slow up.
Oh, for sure, like the public trying to come in. And then like, okay, let's say your client downstairs has a fever. Who's gonna communicate that to the judge or?
Oh, yeah.
Because they're not gonna let them in.
They need to think about that.
Because like the homeless clients don't have phones, likely are gonna just in general be sick.
Maybe they created a list downstairs of people that they don't let in, if they have a court appearance.
Yeah,
Either way.
I don't trust that.
I don't either.
I don't trust that. I don't know. I mean, like,
You know, the detective,
who did?
you know, that were on YouTube, yeah, but it's small.
I forgot what she.
Can you check with Mr. Franklin to see if he needs 2 more minutes? Because if he needs 10 more minutes, they'll need to do this in a different place. Thanks. That's right. That's just because I have the speaker up, then you have to hear every time I delete an email. Sorry about that.
Where should I place this waiting for?
If you just put it on the witness stand, or you can hand it to me, I am getting them to Deidre.
I did test negative, so there's that.
All right. Where did you go?
The Fulton County Center, the behavioral.
The one on Boulevard?
Mhm.
How was that? Is that the walk-up one?
Yep,
Did you make an appointment?
I did, and I was there for less than 5 minutes. It was very fast.
How does it? Do you park somewhere and then you walk up,
They
or?
have a big parking lot right behind it.
Okay, and then you go in, and then do you administer the swab?
Do it yourself.
That's what a colleague was saying. He went to the one that's in North Fulton. He said they give you this thing and
Yeah,
that's it.
it's nowhere near as scary as they make it out online for like large. That does not happen.
All right.
How did you get in that lot that's right beside there?
So you make a right onto the street and then a left into the lot. The lot gate is open. So there's like a
So you
private
don't have to
lot
have
for
a pass to
employees.
open that gate?
There's a private lot for employees. You make that immediate right, and there's a public lot
Oh,
that has spots.
I just paid
Oh,
the
no.
parking deck twice.
Twice.
Yeah.
That was the first time I went in and they they said, oh, well, you need to go all the way across Boulevard and to the end of the street, and there's a Fulton building down there, so I went down there to find out that wasn't where I was supposed to go. And then I came back and, later on parking lot, so.
Great, thank you.
They have new signage out, so you must have gone before I did.
Well, they asked me, they said, well, didn't you need signs? And I said, what signs? And they said, the big yellow signs, and I found them all laying flat. Well, that didn't really help.
Oh, that's frustrating.
I needed the exercise, so I went.
It's been Wendy's, so it's probably what happened.
Mr. Franklin, I received news from Ms. Nelson that there is in fact a detainer on Mr. Hernandez. Just, you're welcome to confirm it, but just to spare you that, she was somehow able to.
It's likely listed on the booking screen, you just said maybe it wasn't managed.
I don't know, she is the Odyssey expert in Chambers, and so she heard we were talking about that and shot me a message saying it's there. So, all right, thank you for doing that. So you're around between now and 2?
I am around until 5 o'clock.
Okay, and you'll be up on
I'll be in New York.
6? Okay, great, I'll track you down, thank you. Sure. Ms. Patel, are you ready for Mr. Brown?
Yes, sir.
All right, why don't we bring Mr. Brown out, please? Thank you. Good to see you. Thank you for helping.
Thank you.
Okay, position 3 on our inquiry calendar, State versus James Brown. It's indictment 20 SC 175795. Good morning, Mr. Brown. I'm doing all right. How are you doing? Okay, well, I bet you could complain about some things, but I appreciate you keeping it short right now. Mr. Brown, this is your first time coming to court, to Superior Court, in connection with your charges. It's the arraignment date. And Ms. Patel has already filled out on your behalf a waiver of arraignment, which just means that you understand what you're charged with, you're entering a plea of not guilty, and you're ready to have this case move forward. I'm gonna let Ms. Patel add whatever she wants. I need to understand from the state if there's anything that would make it difficult for them to get discovery, but I want to get a scheduling order in place so we can make sure your case is moving along. And I suspect we'll have a bond hearing in your case soon. Ms. Patel did ask if we could talk about bond today, but the state is entitled to notice. They may want to have someone offer a perspective. There are alleged victims in your case. So it may be that the alleged victims want to be heard. They have a right to be heard, just like you have a right to be heard. And that can't happen without notice. So we will not be talking about bond today, but I suspect in the very near future we will. It may be that Ms. Patel asks you about your willingness to have the bond hearing all via Zoom. There are actually some lawyers and people that are listening in. They can't see you right now. But that may be a sooner way to do it, where you would be out at Rice Street and you can see and hear, and Ms. Patel might be at her office or here, but we wouldn't all be in the same place. But that's a conversation for you and Ms. Patel. We are trying to bring inmates over here more regularly. You are the first batch to be here in 3 months, and we'll see how that goes. If it doesn't work smoothly, then we'll have to go back to Zoom only. But I wanted you to know we are trying to move things along. You've been in jail for over 100 days now, and we need to make sure we're doing what we can to move your case along consistent with public health measures, et cetera. So Ms. Patel, tell me what you think the next steps are in Mr. Brown's case.
Your Honor, I would request a bond hearing whenever, if the state needs less than 2 weeks, if they can just let us know, and that might speed things along. I'll speak to my client about the waiver of presence. And then perhaps, Your Honor, if the state's intention is to re-indict, to place it on an inquiry calendar. I know that grand juries aren't currently occurring, but if and when they are, so that we can track that. In the meantime, we can move forward with the schedule on this case until that.
So my advice would be for both sides to move forward as if these are the charges. I don't speak for the chief judge, but I think it's safe to say that no one's going to see grand jurors for a long time.
Right, that's my understanding.
We're going to see pettit jurors before we see grand jurors. So it's going to be, as they say, a minute. And we ought to assume that these are Mr. Brown's charges. And so you ought to insist on getting discovery and then process that discovery to see, are there any motions you want to have heard? If the state elects to change the charges when there are grand jurors, we can react. So I'm not saying don't ask for it to be on an inquiry calendar, but I don't intend for any case right now to say, let's just wait until we get grand jurors back in, unless both sides say, we'd like to wait. I don't know, I mean, maybe that would be a case where it's death penalty or something like, well, we have months to burn. But it doesn't sound like this is that case. So I don't intend to move this more slowly because of what we've heard from the state, not because I discount what they're saying. It's just, it is a procedural obstacle that ought not to burden a defendant's ability to have the case move along. That doesn't mean, hypothetical, this ends up with a plea that the sentence is a whole lot more serious than one might think looking at these charges if information comes out that it was more serious than these charges would suggest. But that's many days down the road. And my thought is we ought to move this along as charged. Ms. Hall, is there any reason why the state wouldn't be ready for a bond hearing at the next available notice calendar? And by notice, I mean to the lawyers. Mr. Brown will be brought over. I just don't know where Ms. Nelson can put it. My guess is it'll probably be about 2 weeks out anyway. But to be prepared, you don't need to have provided discovery. Obviously, the more you can get to Ms. Patel in advance, the better. But it would be you and Ms. Rolak and maybe Ms. Hodge thinking through what the bond hearing would be like. But any reason why the next available calendar would be too soon?
No.
Okay. Then I'll work with Ms. Nelson to get it on a calendar. You should, Ms. Patel, file a bond motion just so that the file has that in there and everyone is officially on notice. But we'll get Mr. Brown. Well, I guess what you'll need to do is let Ms. Nelson know, can it be a Zoom calendar or does it need to be an in-court calendar? Ideally, they'll be both going forward. Okay. Ms. Hall, anything else in connection with Mr. Brown's case? So you have the file. You may not have it right in front of you, but I know you shared with us that ultimately this case may end up with CWAC. Until it gets re-indicted, is it your case or is it now Ms. Hodges' case?
So technically, CWAC is in a completely different department in our office. So from my supervisor, she told me to hand it over to CWAC because it is their case. But there is, issues with indictment case, so I didn't go ahead and order discovery.
Great.
I was just being
Sure.
Not that sensitive, but as in they do.
Got it.
So, well, I'll work with her and we'll figure out how to, I'm sure we'll do it.
Okay. Ms. Hodge, I was asking, in case you could not hear Ms. Hall, who is going to manage this case for the state going forward, given that the charges aren't going to be able to change anytime soon? And Ms. Hall explained that her supervisor, who I assume is Ms. McCauley, had indicated that the case ought to move to CWAC now and not waiting until it's been reindicted. I'm not getting in the middle of that. I just want to make sure that when Mr. Brown, is next on a calendar, we have someone from the DA's office who says, I am ready to go forward. And if that's you, that's super. If it's Ms. Hall, that's fine too. I just don't want us to run into a situation where it's on a calendar and one of you says, it's not my case, so I can't move it today. But you two coordinate real well. So let's just make sure you keep doing that, because it sounds like in the next few weeks, we'll be talking about bond in Mr. Brown's case. I think the more info you can push across to Ms. Patel that falls into the category of upgrading the charges, the better. All that's in the docket right now is a police report that doesn't have much. And it includes a supposed eyewitness saying nothing happened and the ladies are making it all up. So it sounds like there's more, and maybe that you can get some of that to Ms. Patel. It's not a requirement. We'll set a scheduling order, but it certainly would be helpful. Ms. Rolak, I noticed you came off mute. Was there something you wanted to add from the victim side?
I didn't realize it was off mute, Judge.
Okay. Everything good from your side?
Yes, Judge.
Okay, great. Ms. Hodge, was there something you wanted to add?
No, Your Honor.
Okay. And Mr. Brown, just so you understand it, just your case may end up in a different unit. It's going to be your lawyer, I'll be the judge. It just may be a prosecutor other than Ms. Hall who handles it. And that prosecutor is on the Zoom call. She can hear what's going on. You can't see her right now, but you'd see her if we're doing this on Zoom. So that's where we are. So Ms. Hall, when we establish a scheduling order, same as with Mr. Hernandez's case, about a month to get discovery in case there are things that you need to get from a law enforcement agency as opposed to already in your folder. Okay, all right. We'll get a scheduling order for Mr. Brown's case out as well. Ms. Patel, anything else for Mr. Brown?
Nothing further, Your Honor.
All right, well, we'll look for your motion and then please let Ms. Nelson know which format Mr. Brown's willing to do in terms of a Zoom calendar or an in-person.
Would he be present for Zoom calendar? Meaning, could they bring the laptop to the floor like they've done in the past, or would it just be without him present at all?
I wasn't clear. I view there are three options.
Right.
What I was talking about was either Mr. Brown here in court, we're all in the same space, or like what we're doing this afternoon, where Mr. Brown is involved. He is present virtually. He's on the screen, you're on the screen. He can see and hear, and you guys can go into the breakout room. So that's what I meant. I wasn't thinking, but there is that third option, and we've done it occasionally, where a defendant says, I don't even need to be there. Lawyer, do your thing. That would be the quickest way to have it happen, because it doesn't involve coordinating with the sheriff's office. We can set up Zoom hearings as long as you and Ms. Rolak and the victims and Ms. Hall or Ms. Hodge are available. But I sort of get to tell you guys that. The Zoom calendar like this afternoon, we have to wait our turn in the rotation. So I had forgotten about that third option. You and Mr. Brown talk about it and then let Ms. Nelson know. Okay. All right. Thank you.
Thank you.
Yes, ma'am. Mr. Franklin, do you need time with Mr. Anderson? We're not going to bring him out right away. We'll get set, but do you need time with him? Okay, then why don't you head on back? Ms. Hall, these are negotiated, please? Okay. It's a lot of burglaries.
It's a storage area.
Judge, we'll have to go on a copy on one of the indictments. One files in Judge LaGrua's chambers and no one's available to get it.
Okay, Monica did try.
Right.
All right, so I've got 891. We'll do a copy of 786. I'll print that out right now. All right, I'm gonna go get a copy of the other indictment. I've got the original I did print it. You want 2 copies? Sure. Well, I was gonna just give it to you. I'll make a second copy, but I was gonna give you the copy to work. Here's the original in one, and then I'll bring out the other one, and then you can use it, because that's what you'll need to sign and everyone. So here is 891. I'll be right back with the other one.
So you're just gonna stay at your desk?
Yeah, I think it's.
That's fine. Just if you'll make sure the microphone's closer to you, but I'm hearing you fine. The problem we have here is they put in this FDR system, put in microphones. That's actually replacing. It's an electronic recording system. They replace the code.
Oh, really?
The problem is when they did that, connecting all the speakers in here, except for those 2 on the side, and the little bitty ones at the bottom of your microphone stand. I have no way to hear a bunch of stuff that goes through those microphones. So I've got little microphones myself, take up here and have them around the courtroom. So right now I'm trying to move things around, figure out what's going on, and that's why I was checking them earlier about if there's any way I can tap into it. I came down here, spent 4 hours one day, crawling around on the floor underneath everything, trying to find a way to tap into it. And it's a sealed system, so that can't, but I saw the Asian one, he said, we'll find a way. Works for me.
Yeah. They trying to replace us.
Yeah, well, I look at it this way. I'm on loan to Judge McBurney and Judge Brasher. Here, they don't have to do that. So,
All right, here are both indictments. Sure.
that's my file 3 years ago. You just go look to the police.
It's always been.
Okay, good.
You found it pretty fast.
I tried. If you ever have an issue, let me know. I'll get it.
Okay, thank you.
They are right there. We have one original, one copy. So Judge Reeder took a plea for co-defendant in
January 28th.
one of these cases, yeah, for Khalil Chavies,
Correct.
Ms. Snyder's client. If that sets a marker. So we should talk about, we haven't had a plea yet. What logistics make the most sense? If you're at the podium and the microphone at the table is on, Mr. Anderson can be heard. You guys are separated, which is appropriate, but also awkward if you need to talk to each other. What's your preference?
Until a moment comes up where we need to whisper or something. This is appropriate.
Good.
I have my mic, he has a mic.
Right, and Ms. Hall has a mic. So historically, please, folks have sort of clustered around the podium. All these microphones work. Mr. Anderson, is the green light on that microphone?
Yes, sir.
Great, so you can be heard. Mr. Franklin can be heard with or without a microphone. Ms. Hall, is your microphone on? Great, so let's stay in our positions. And I'll get on the record in a minute. You're right to have a conference with Mr. Franklin if something comes up, and we'll figure out how we do that, okay? All right.
Oh, no.
All right, so Ms. Hodge, I think we're done with your cases on this calendar. You're welcome to stay on Zoom, but we're taking 2 pleas for the last 2 positions.
Your Honor, I was just staying on to see if you had any announcements or wanted to talk to us moving forward. But if not, then I will ask to be excused.
Why don't you stay on? Because it would be good to have a group huddle after this. So
Okay.
You can go back to doing whatever you were doing. I didn't mean to interrupt. Thanks.
No problem. Thank you, Your Honor.
All right. Okay. Mr. Forte, you ready? Mr. Franklin, everything's been signed. We've got a plea form and then 2 indictments.
Correct.
Great.
I didn't do the plea form.
Okay. Next time, let's do a plea form.
Understood.
You're rusty. I'm rusty too, but they should be there for future reference. I think they're out there. They're the big bulky ones. Okay. We'll do them next time. Then let's get on the record. This is, these are positions 4 and 5. on our inquiry calendar. Both are State versus Garrett Anderson. Both involve burglary in the second degree charges. Mr. Franklin is representing Mr. Anderson. Ms. Hall is here for the state. And it's my understanding, Mr. Franklin, that Mr. Anderson is prepared to enter negotiated pleas in both cases.
That's correct, Your Honor. We are asking that these cases be consolidated for purposes of trial, for purposes of plea, and we're asking these sentences as first amendment.
Okay, we will consider that and we'll get input from Ms. Crawford as to Mr. Anderson's eligibility for that. Good morning, Mr. Anderson. How are you doing? Okay. You are interested in entering pleas in your two cases. If we're going to do that, you have to be put under oath. So in just a minute, Ms. Hall is going to administer the oath. Once you swear to tell the truth, of course, you have to do that. You'll need to answer all the questions that Ms. Hall has and that I'll have truthfully and completely. Along with that responsibility comes the important aspect that you need to let Mr. Franklin or me know if you have any questions, if someone asks you doesn't make sense, you just don't get what's going on. I need to make a finding at the end that you made a knowing and voluntary waiver of all your rights. And the knowing part means you understood everything. So if something comes up that you don't get, or it's just different than what you thought, will you let me know? Okay. All right. The other thing, Mr. Anderson, is that normally or historically, your lawyer would be right next to you. And so if you had a question, you just sort of whisper in his ear, or he might whisper in like, hey, this is what the lawyer meant by that. That's what the prosecutor meant. We are appropriately keeping folks 6 feet or more apart. If something comes up where you would like to confer with Mr. Franklin, let me know, raise your hand, do something, and then we'll figure out a way for the two of you to chat. This should not be a complicated process. There are no trick questions or anything, but it's important. And if there's something that you want to discuss with Mr. Franklin, then let me know and we'll make it so that you guys can talk about it. All right. Ms. Hall.
Thank you. Your Honor, just a quick off-the-record question. They're saying they can't see you on the Zoom. I don't know if that's intentional or not. I just wanted to mention.
So, who's they?
Ms. Rolak, they're victims on the watching in as well. So apparently their screen is black on their end.
Okay, we can do that. Now they can see me. It's not going to be real interesting. It's not the courtroom, which is why I had the screen just black. But if they,
I think she just wanted to know if that's their intention. So
okay, it was purposeful because we don't have a system in place where what is shown is the podium or the speaker. And so rather than seeing my receding hairline here, I figured we could just have it be the way it was. So I'm going to sign off again in video format, but the folks who are plugged in via YouTube should be able to hear what I'm saying, not necessarily what the lawyers say. Again, we're working through the technical aspects of hybrid hearings where some are connected via Zoom and some are in person. All right, thank you for flagging that.
Back on the record.
Back on the record.
Good morning, Mr. Anderson. Can you please raise your right hand? Do you swear or affirm the testimony you should give and not occurring before this court should be the truth, the whole truth, and nothing but the truth? You go ahead. Please state your true, correct, and legal name.
Garrett Jerome Anderson.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine? Is there any medication that you normally take that you have not been given today? How old are you and how far have you gone to school? Are you able to read, write, and understand English language? Do you understand in indictment number 19SC 172891, you've been charged with 10 counts of burglary in the second degree and 5 counts of theft by taking? And do you understand that indictment number 19SC 173786, you've been charged with 2 counts of burglary in the second degree? Do you understand for both of those cases and indictments that you have the right to plead either guilty or not guilty? And if you plead guilty or remain silent, you may receive a jury trial?
Yes.
Have you had enough time to speak with your attorney about all the facts and circumstances known to you regarding the charges in either of these indictments, including any potential defenses? Do you need more time to discuss this case with your attorney? Are you satisfied with his services?
Yes, ma'am.
I'm not gonna walk over, but I'm gonna show you, both of the indictments. The first indictment being 19 SC 172891. Have you had a chance to go over this indictment with your attorney?
Yes, I have.
Do you understand the charges that the state is moving forward with against you?
Yes, I have.
Is that indicated by your signature on the document?
Yes.
Thank you. And indictment 19 SC 173786. Have you had time to review this indictment with your attorney?
Yes.
Do you understand the two charges that the state is moving forward with against you?
Yes.
Is that indicated by your signature on that indictment?
Yes.
Thank you. Counsel, do you wait for, as we approach the indictment?
Sure. Thank you, Mr. Franklin.
Yes, sir.
Counsel, do you wait for the reading of either indictment?
So wait,
Do you waive any or defects of the indictments, including with respect to the defendant's name?
yes, for purposes of this plea only.
And do you waive moving forward with a copy of indictment 19 SC 173786?
Yes,
Mr. Anderson, have you been arrested on all of these charges that I mentioned to you previously? I asked because the state is unaware of any outstanding warrants that are related to either of these indictments. Do you and your attorney know of any outstanding warrants related to these charges?
I'm not aware of anything else outstanding. I believe the last warrant has effectuated his custodial status at this point.
Mr. Anderson, has your attorney advised you of the minimum and maximum sentence to each charge that you're pleading to? The minimum and maximum for all of the verses in the second degree are 1 to 8 years to serve in prison, and the minimum and maximum for the theft by taking charges that you're charged with are 1 to 5 years to serve. Do you understand? Do you understand that this is a negotiated plea? I'm sorry, do you understand that this is a negotiated plea of guilty, which means the state will recommend to the court in case 19 SC 172891 and also 19 SC 173786 for the burglary charges, 10 years probation for all of the burglary charges in both cases. And for the theft by taking charges, 5 years probation to run concurrent to the burglary charges, in both cases to run concurrent to each other. Also restitution in the amount of $42,000 paid to 9 different victims. I will give that information to probation.
So two things on restitution. One, it's 42,000 is the total if you add up the losses for 9 victims.
Yes, sir.
Okay. 2, I'll let you email to Ms. Nelson and Ms. Crawford that information, because I think that the final disposition ought to have it broken out by victim. So if Fred Smith is entitled to 2 of the 42,000, it should say Fred Smith $2,000. And then you can get the contact information to probation. We don't need to have the contact info for each victim, but I think it's appropriate to have it broken out by victim. You don't need to get that on the record here if restitution is something you and Mr. Franklin have already talked about. If he is surprised by this number and that there are 9 victims, then we will need to get more on the record. But if it's part of the negotiation, then you don't need to rattle off the names and the specific amounts, but we will need to incorporate that in the final disposition.
Yes, Your Honor. Now, there may be a hometown list that was filed with the Michigan Custodian, because this case has started off with me. I'm not sure if it was actually filed, but with our complaint package, what came in from when the complaint when we got this case was a breakdown of every victim minus the victims of the second case. They are on the line watching. But as me and Mr. Franklin have discussed the restitution, I think that defense was to be satisfied for one particular case once they receive some type of proof or receipts or anything of that matter. It is a significant amount. It's $20,000 for those 2 individuals within themselves because their guns that were stolen. So that's why that amount is so high. But other than that, I think we are in agreement with the restitution amount for both defendants in this case.
So the 42,000 includes the 20,000 that you just referenced?
Yes.
And that 20,000 comes from the second indictment? Or-
The 20,000 comes from the second indictment, the 22,000 comes from the first indictment ended in 891.
Got it. Right. So, Mr. Franklin, I know we're on topic, but we're pausing here on restitution. I just don't want it to be something that unspools the plea in the end. That 42,000, that's not the first time you've heard that number?
No, we first thought we were gonna plead this case in January. The number was 20-ish thousand something dollars. But that's
Because it was only 891.
correct. During our discussions in this COVID era, Ms. Hall has mentioned that number before. I spoke to her today and said, I would like to see the total, why they came up with that number. So as long as there is some evidence of that, we're not here to make that the issue.
Okay.
But we just want to make sure that, if the gun was a $1,000 gun, and they're not saying for $3,000.
Sure.
I have no reason to doubt them necessarily, but just being clear and certain.
Sure. And this is joint and several liability with the other defendants?
Well, it was supposed to be, Your Honor. I wasn't a part of the original plea. I was sitting secretary on the trial, and whichever ADA represented me at that time, I noticed that on the disposition, it said the restitution was to be determined.
Okay.
So I don't know if they weren't clear on what the amount was that they covered, or something else happened between Judge Reader and the taking of the plea. I'm not sure because I wasn't there, but I did notice that the restitution did not attach to the co-defendant. It said it would be determined.
Okay. Well, I'm going to make a note that you and Ms. Snyder should speak. If she is not comfortable agreeing to an amended sentence for, do we pronounce it Chavies? Chavies, Mr. Chavies, if she's not agreeable to that, then we'll have a hearing on it. But I think we increase the likelihood that the victims receive some restitution if there is a clear obligation for all the defendants who've admitted guilt. And Mr. Chavies has already pled guilty. So we'll circle back on that. Okay, so I'll hear what the recommendation is in the end and the urgency of getting a final disposition entered. And we'll talk about how that might look. If the goal is to get Mr. Anderson out ASAP, it might be that I include a restitution amount of 42,000 subject to Mr. Franklin being comfortable with that. Because the other thing I could do is take the plea, but not enter the final disposition until you, Ms. Hall, have provided Mr. Franklin with the additional supporting material that I know you'll be able to get. But I'll hear from you both on that when we get closer to the end. All right, back to your colloquy.
And I'm gonna break the case down from the negotiating part just to keep it clear. Mr. Anderson, do you understand that this is a negotiated plea of guilty, which means the state recommends to the court in case 19 SC 172-891.
But I'll hear from you both.
8 counts of burglary in second degree, 10 years probation, and for the 5 counts of theft by taking, 5 years probation, so we're returning to each other. Restitution in the amount of $22,000 to be paid on several victims. The court did not accept their recommendation. The court can sentence you to the maximum on each of these charges and can run those sentences consecutively and will not to and as far as case 19 SC 173-786, do you understand that this is also negotiated plea of guilty, which means the state recommends to the court a sentence of 10 years probation for both counts of burglary in the second degree. But the court does not, plus restitution in the amount of that case of $20,000. But the court does not have to accept that recommendation either. The court can sentence you to the maximum on these charges and on those sentences consecutively. Jackson, do you understand that this is a guilty plea which is permanently reported on your criminal history? Do you understand this plea may be used to enhance sentencing for other convictions in this jurisdiction as well as other jurisdictions, including the federal courts? Do you understand if you're currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea? Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence? Do you understand that you're not allowed to possess or use a firearm on probation? Do you understand that if you're not a United States citizen, the guilty plea conviction will affect your immigration status and will result in deportation? This as conviction of trial visit, and this is true regardless of any advice by your attorney or anyone else. Do you understand there may be other adverse or unfavorable consequences to you as a result of this guilty plea conviction, just as there will be from a conviction following a trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve as a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment. Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony which may carry a sentence of 1 to 15 years in prison. In case 19 SC 172891, are you asking to be treated, I'm sorry, and in case number 19 SC 173786, are you asking to be treated as a first offender under the provisions of the First Offender Act? Have you ever pleaded guilty on those in trending 2 or ever been convicted of a felony in the state of Georgia or any other jurisdiction? Have you ever been sentenced for any crime, felony, or misdemeanor under the First Offender Act? Has your attorney explained the First Offender Act to you? Do you understand that if you violate the terms of the first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked, you could be adjudicated guilty, and you could be resentenced up to the maximum sentence for each charge in both of these indictments? Do you understand that you waive any of our offenses, including any mental health offenses, by entering a plea of guilty? Do you understand that if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to remain silent and not incriminate yourself? Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial. Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea? Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yes.
Indictment number 19 SC 172891. How do you plead to the charges of 10 counts of burglary in the second degree and 5 counts of theft by taking?
Yes.
And is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, it is.
Do you understand that you only have a limited right to appeal this guilty plea conviction? Do you understand that you only have 12 months from today for misdemeanor charge and 4 years from today for felony charge without a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, sir.
Thank you. And in indictment number 19 SC 173786, how do you plead to the 2 counts of burglary in the second degree?
Yes.
And is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, it is.
Do you understand that you only have a limited right to appeal this guilty plea conviction? Do you understand that you only have 4 years from today for a felony charge without a habeas corpus petition challenging the voluntariness of this guilty plea? Thank you. Your Honor, the state is not aware of any prior felony convictions by this defendant, and had this case proceeded to trial, the state would have proven that on September the 6th, I'm sorry, in indictment number 19SC-172-891. In this case, has proceeded to trial and state with improvement that on September the 6th, sorry, that on September the 6th, 2019, at 4654 Roswell Road, Sandy Springs, Georgia, in Fulton County. Officers were called out to that location in reference to a burglary that had taken place to several different units that was located at the storage unit. It's called public storage. I'm sorry. I'll just read the whole thing.
It is called public storage. I've looked at the indictment. It sounds like Mr. Anderson and Mr. Chavies broke into a bunch of PS public storage units at the the Roswell Road facility on Sandy Springs. That's the burglary part, and the theft by taking is what those two gentlemen took from Mr. Breen, others' units there.
Right, and the officers were able to identify the both suspects, and it is a third suspect as well. There's a kind of more suspect.
Is that Mr. Reed in the other case, or?
No.
No?
In the case that was indicted in December, it's a third defendant attached to that case. It's still involved, it still deals with this burglary and this public storage unit, but that particular incident happened in October and November.
Okay.
And they saw the same gentleman that they saw in September on the footage. They saw those same gentlemen in the footage in October and November. So that's why that case came in later, because that was reported later by those victims that found out those items were stolen.
So let me make sure I'm following on the indictment ending in 891. These 10 units or 9 units plus public storage in general, they were broken into at the same time, the same evening?
Yes.
Okay.
The first one.
Yeah. And what connects Mr. Anderson to those?
So that was the very first one. That was when the report was two black males had rented a vehicle, a small U-Haul. And on the surveillance, the victim was able to see that when they came to the storage unit, they never unloaded anything from it, so it became suspicious to that person. They called 911. 911 came out. There was nothing legal going on at that time. There's nothing actually in the storage. They rented storages from this location. There was nothing in their storages, so there was no crime being committed. But later, they were able to find that there were victims of storage being broken into. When they ran back the surveillance, then they saw the two gentlemen that police had they encountered earlier. They saw those two on the surveillance, and that's how they were able to identify them. Yes, they happened all at the same day, but it wasn't all discovered the same day.
Okay, but how, from looking at a surveillance video, unless someone recognized, oh, that's Garrett Anderson, how did Mr. Anderson become a defendant in this case?
Well,
Because he had a unit there?
Yes, he had a unit.
Okay.
So when the police came out and talked to him, then they were able to pull back up that same information when they saw him on the surveillance video with his phone.
And where did they recover all the things that were listed as having been stolen in counts 11 through 15? There's specific, somewhat specific things taken. Just for example, count 15 talks about a tool and a dolly taken from a Mr. Walters. Were those things found, and if so, where? Or that's just what was taken?
That was just what was taken. It's our understanding nothing has been returned. They weren't able to get anything back that was actually moved from the property or taken from the actual property. Nothing was returned, including the dollar. The dollar was something that was being rented by U-Haul as well. So
law enforcement did not find inside Mr. Anderson's storage unit the belongings of the victims?
No.
Okay. All right. Okay. Then what about the other case?
The other case is just when those particular victims, and they are the victims that are, I believe, listening on, when they discovered that they had items missing out of that unit, it's two people on property inside that one unit, but it is 3 different victims, if that makes sense. When they discovered, they reached out to owners of that location, and when they ran back those surveillance cameras, they were able to find these same individuals who previously, the month before, had broken into those storages, and that's why those ones came later.
So it's a different address. The second indictment involves storage units on Collier Road, that's counts 1 and 2, and then storage units on Lenox Road, count 3 and 4. So same type of scheme, but different location.
So with the location, they knew the individual, yes, I'm sorry, yes, complete different locations, but, and that was Space Shop, the one on Lenox Road. And it sounds complicated because these are individuals going around to storage, but everybody didn't participate in each one of the acts. And so I'm trying to remember everything in this.
So Mr. Anderson is just counts 1 and 2 in the later indictment, 786. He and a Mr. Reed are charged with breaking into 2 storage units at the Collier Road address in November.
Yes, Your Honor. That's what indictment I'm referring to. So in that same indictment, it hasn't been in that same indictment, 3 and 4 are the person I told you that still has the warrant out on.
Yep.
And his other co-defendant, Reed, and he's only charged with counts 1 and 2 on that indictment for the Lenox, where the Space Shop burglary, but not the second burglary.
Okay, so Mr. Anderson was linked to the Collier Road storage units because now they recognize the person from the surveillance video.
Okay, yes, Your Honor. So the officers in the same area investigating this now later, month or 2 later, burglary. They made contact with the manager from the first burglary, got the surveillance, reviewed that because it was different officers on the second burglary. When they made contact in their investigation, that's how they came together and realized that these were all the same people that were involved in the earlier burglary. I'm sorry, I've been missing that question this whole time. So when they started to investigate, they made contact with the older burglars in the other location, the public storage location, and that's how they were able to locate or connect him with this murder.
Okay, one more question. You mentioned that there was an unidentified person. So if we go back to the Roswell Road, Sandy Springs, the thick indictment, were you saying that the surveillance showed that there were actually 3 people involved, or it was only 2, Mr. Anderson and Mr. Chavies?
Well, that one was only 2.
Okay.
The second one, that happened later in October, November, 3.
Okay, got it.
The first one was only 2 black men seen on the surveillance.
Okay, all right. Anything else? All right. So Ms. Crawford is on Zoom, and she has confirmed that she's a probation officer with Department of Community Supervision. She has confirmed that Mr. Anderson has no adult criminal history, no adult felony criminal history. So it sounds like Mr. Anderson is eligible for first offender. Mr. Franklin.
Thank you, Your Honor. So I'll begin here. Police encountered Mr. Anderson during this first thick indictment situation, and they had suspicion that they had used ID and all that kind of stuff. So I believe that's a portion of why they had this information to begin with, when they later realized that, a bunch of units had been broken into. Mr. Anderson, as you know, people in the Atlanta community sometimes do, in his neighborhood, there's a guy named Red. They need to have his stuff moved. He offered to pay Mr. Anderson to rent the truck because nobody else had, I guess, a suitable license to spend mass license or something. So Mr. Anderson thought that he was engaged in something to just make a couple bucks real quick. He did not share and keep any of the proceeds of the burglary. And from my understanding in discussing the case with Mr. Anderson, he was either in the car or at the door of the facility, and the other guys were bringing stuff to him. So as it pertains to the actual physical, who broke into the locker, I'm confident he wasn't part of that portion of the scheme. I think he thought that he was a part of just literally moving. We came to court in January, received the offer of probation, but because there was the co-defendant had not been arrested or wasn't present in court that day, we were gonna reset so they could take the plea at the same time to address the restitution issue and make sure that it was clear. Ms. Hall was called to trial. Somebody else covered for her one day when Mr. Anderson was able to make it, and the co-defendant made it, and he was allowed to complete that at the time. So it kind of created this mambo jumbo, but
it says that Mr. Anderson's only been in jail for 17 days. What happened? Was he was out on bond originally?
So they then indicted the second case. He was arrested on the warrant for that.
Okay, it's a direct indictment. This is the LaGrua case.
Yeah.
Okay.
So he was arrested pursuant to the second indictment because those charges were never made a part of the first one, but it's not as if he got out, did something else or anything. It's just
Okay.
how the timing of things went.
Got it. So he's not denying involvement, but it's the story we've heard before where Red paid me to help move some stuff, no questions asked, and I helped move some stuff. Okay. And it happened just coincidentally to be a storage facility where Mr. Anderson had a locker?
Perhaps.
Okay.
Actually didn't discuss that portion of things very much.
Okay.
To be quite frank with the court.
All right.
And as it pertains to the second case, the discussions were kind of quick because we had the initial offer. I asked, well, would that be something we could just wrap up into the same thing? And it made sense to do so from our perspective. And being that the co-defendant had already received the deal that we attempted to take before.
Yeah.
It wasn't fruitful to kind of get into the weeds about let's plead to this one, but let's fight this other.
Right.
Because I believe that he was only present for the moving theft stuff that occurred in September. Not necessarily stuff that actually occurred in November, but it's not an argument because then we deal with similars and all this other kind of stuff.
Right. A lot of similars.
Right.
Right.
So he dropped out of school, but he did get his GED. When I first met him, he was working at Burger King, but he was interviewing, trying to find better employment. Before his second arrest, as it pertains to the second indictment, he had gotten a job at UPS. He had been working at the hub over on Folsom Industrial. Making pretty good money. He had been working 29 days before he got arrested. He's fairly confident that within a month, he should be able to get that employment back. In order to facilitate restitution, we will be asking that the probation fees be waived. I think whatever money he does make and take to pay towards restitution should go to the victims of the crime.
Mm-hmm.
And I know when you began, you were trying to figure out, do we sign off on everything now and just get them out? Being that we have entered a guilty plea, and it's just a matter of when we sign it, maybe we can entertain the option of a signature bond at this point so we can get out and get to work while we figure out the restitution amount for the second portion of things. I'm not sure that's too complicated given how we have to do court now during COVID. I know if we had regular standards in place, it would not be much of an inconvenience, but did well while he was out on release. He found better employment, so I think that under the circumstances he should begin working towards making his restitution.
Okay. Mr. Anderson, who is Mr. Chavies to you? How do you, is he a friend? He's a business associate?
Just the guy I know from the neighborhood.
Is that Red? Is that the same, or that Red is someone different? Okay, so Mr. Chavies is someone you know from the neighborhood. What neighborhood? Okay, and is that where Red was? Pardon me?
Yes, sir.
Okay. Okay. But you just knew Mr. Chavies from growing up or living there? And did Red ask both of you to help out?
I don't know what he asked him personally. I just know what he asked me.
What did he ask you?
Move some stuff into
To rent a storage unit? Okay, so you had a storage unit at that Roswell Road location in your name? You're the only one with good ID?
Yes, with driver license.
Okay, so you're legally mobile and you've got a driver's license. Were you and Mr. Chavies ever at that public storage location together?
One of them, yes.
When you say at one of them?
I can't remember the exact location. The one the police came to, that's the one we went to.
Okay, all right. And did you ever put anything in the storage unit you rented in your name? Did you have the key to it?
I did.
Okay. Did you give a copy of the key to Red? Okay. All right. But you weren't putting stuff in the unit. If something was in there that was red. Okay. When did you figure out or reasonably suspect that maybe things weren't on the up and up? That's one way to figure it out. But before then, you claim you had no idea. Okay. All right. So the restitution is a large amount. You are going to be jointly liable with Mr. Chavies. And then if we ever identify Red, and that's something you may choose to do, I can't require you to do that. But if you get information about Red that you want to share with Mr. Franklin, he might be then able to share it with the prosecutor, and Red might be in a good position to pay some of this restitution. It sounds like he ought to as well. But until we know Red's real name and he gets in front of a judge, poor you and Mr. Chavies are carrying that burden because we don't have anyone else to push it off to. But it's certainly not the burden of the folks whose stuff got taken. And I think Mr. Franklin's helped you understand how you were part of that process. You may not have been the mastermind or anything like that, but in the end, you helped make it possible for a number of folks' stuff to be stolen, and now it's gone. And looking in the indictment, it wasn't necessarily replaceable things. If it's a TV, it's not good, it's a crime, but I can always get a new TV. But some of it was personal effects. I don't know what Red does with someone's photos or their yearbook or whatever personal effects might be, but I do know that you can't go buy another one of those. So this is more than economic value. And to go back to my starting point, you and Mr. Chavies are going to be working off that $42,000. It's going to take a while. So if you decide you want to figure out who Red is and pass that along, that will help shift the burden to where maybe it ought to go. And then Mr. Red can start paying some of this restitution as well. Food for thought. Where would you be living when you get out? Did you have your own spot before you got arrested?
Yeah, I was living in a rooming house.
Okay. But whatever you had in that rooming house is probably gone now.
Yeah, I got my brother to go with my things for me.
Okay. Your mom will take you back?
Yes, sir.
All right. And then you're hoping to get the UPS job back?
Yes, I've talked to my supervisor already. He told me I can be back on the hire list.
Okay, that's good. And how do you get from mom's house to UPS?
I have a car.
Okay, do you still have a car?
Yes, sir.
And your driver's license is still good?
Yes, sir.
All right. Where is the car?
It's at my brother's house.
Okay, so all your stuff's at your brother's house.
Yeah, I had to go get it for him to make sure it's safe.
Good. Okay. And did you know Mr. Reed? That's the third defendant in this other case. Okay. All right. Anything else you want me to know?
No, sir.
All right. Ms. Rolak, my understanding is that there are some of the victims in one of these two cases, or maybe both cases, who are listening in. They may be trying to watch. I can turn the video on now since I'm facing the camera. The footage is of either the side of my head or my face, so that's why it has been dark while I've been engaging with the lawyers and with Mr. Anderson. Do any of the victims have anything they want to share, either directly or through you, or they simply are listening because they have a right to know what's going on?
They're just listening in, Judge. They declined to make a victim impact statement at this time.
Okay, well, I appreciate that they're staying plugged in, and it's unfortunate that there was a scheme that took their property. and hopefully they have been made whole in part by insurance. And they should understand that restitution moves real slowly. If Mr. Anderson were made of money, my guess is he wouldn't have been wrapped up in this scheme. But if he's going to be a hardworking guy, he will bit by bit help make these folks as whole as restitution will make them. And we're going to modify Mr. Chavy's sentence so that he begins to bear part of the restitution burden as well. That ought to get money in small amounts flowing a little bit more rapidly towards the victims in this case. Thank you for getting them involved.
Thank you, Judge.
Okay. Did you have anything you wanted to add, Mr. Franklin, after I spoke with your client?
No, sir.
The last thing I need to cover with you.
Oh, I'm sorry. Just now officially requesting again for the cases to be consolidated. I believe that the facts of one could be used as a similar fact of the other, so I believe it would be appropriate to join the purpose of the trial and resolution of the first offender.
Okay. Mr. Anderson, I need to talk to you about first offender. Ms. Hall's already covered it, but I need to do it as well. First offender is primarily an opportunity for defendants. If I sentence you as a first offender, this will not be a conviction. So if UPS asks you, hey, have you been convicted of anything? You can look them in the eye and say, no, I have not. You will not be a felon. You'll be on probation, but you're really not under a sentence that you need to report to an employer. You don't have to check that box of I'm a convicted felon. That's the benefit. And if you stay out of trouble and stay away from the reds of the world between now and the end of your sentence, then it is not a conviction the whole time. When you complete your sentence, it gets wiped off. So it is something, it's as if it didn't happen, except of course you'll have been paying restitution and reporting to probation, et cetera. So it's valuable, and you've earned it because you haven't been in trouble before, but it carries a risk. And I need to make sure you understand the risk. If I sentence you to 10 years probation, which is what's been negotiated, and I'm making this up, but 2 years from now, you get wrapped up in another one of these schemes and you get arrested and new charges are brought. Not only do you have those new charges, but because you've pled guilty here, without a trial, you'll get a hearing, but without a trial, I could not just revoke your probation, but I could re-sentence you because you've already pled guilty. And the math is not very favorable for you. I could, it looks like, sentence you to over 100 years in prison. I can't imagine that's how it would play out unless you killed someone, but then you'd have bigger fish to fry. But you need to know that every year of exposure, 8 years for every burglary, 5 years for every theft, that's hanging over your head as a potential sentence if, while you're on first offender probation, you make a bad choice and you get in trouble again. My guess is that it wouldn't be a 100-year sentence. But like I said, if you did this same thing again and you're back here, like, uh-oh, another storage unit caper and Mr. Anderson was involved, I wouldn't be surprised if what I said was, you know what, you're going to do 5 years on this case. No trial. You already pled guilty. Again, we'd have a hearing, but the state only needs to provide probable cause, more likely than not, that you were involved in the new case. I could see saying, I'm going to sentence you as a felon for these 2 cases, and it's 5 years, and then we'll deal with the new case as well. So that's the downside. And I'm emphasizing it not because I think that's where you'll end up. I hope you don't. You're going to be 40 years old soon. Hopefully you're done with this kind of stuff. But you need to understand the downside and let me know that you still want to go forward with first offender. Okay. So you understand the consequences and the benefits. And it's something you think you can manage. Okay. All right. I can appreciate that. I will, for purposes of sentencing, consolidate your 2 cases. And I will sentence you as a first offender because it sounds like insofar as you were involved in the 786 case, it was an extension of the same kind of thing. And it's particularly compelling argument because we have Mr. Chavy's in both cases as well. I will do that. I generally don't like sentences as long as 10 years probation, because probation has better things to do than watching someone for 10 years. And frankly, if you've been fined for 2 or 3 years, you're probably going to be fine for the remaining 7, but this is a whole lot of restitution, and that's the value of 10 years probation. In the case ending in 891, I will sentence you as to counts 1 through 10. Those are all the burglaries, to 8 years. Those will all run concurrently with each other, and they will be probated. Counts 11 through 15 will be 2 years to serve each. They will run consecutive to count 1. They'll be probated. 8 plus 2 is 10. So that's 10 years probation in the 891 case. In the 786 case, you are charged in counts 1 and 2, and I'm giving you 8 years for both those counts. Those will run concurrently with each other. Those will be probated, and they will run concurrently with your sentence in 891. So it is overall 10 years. I am sentencing you as a first offender and pursuant to the Probation Options Management Act. That is simply, Mr. Anderson, a mechanism that will ensure that if while you're on probation, you have a technical problem, let's say you move and you don't tell probation, they'll be unhappy about that, but you don't have to come in front of me for that. And maybe you are making more money than probation thinks you should be making for not paying much restitution. And so they may fuss at you a bit for paying more restitution. Again, you don't get in front of me. But if you get in trouble with the law again, that will come back to me, and we would work through what the consequences ought to be. So that's what the Probation Options Management Act is. I will waive your supervision fees. In the off chance you don't get back to work, to encourage you to get back to work, if you remain unemployed as of July 15th, I'm going to require that you do 20 hours of community service every week until you are employed at least 20 hours a week. You may not be able to find 40 hours a week right away, and you actually may be because of UPS, but if not, then to encourage you to keep looking for employment. If July 15th rolls around and you're not working, or you're only working a couple hours a week, then you're going to have 20 hours of community service each week until you have at least 20 hours a week of work. Does that make sense? All right. I am not going to sign the final disposition. That's the actual sentence in your 2 cases until we iron out the restitution. But what I will do is enter a signature bond in your 2 cases so you can get out and get back to work. You should know that if
you were to catch a different charge before you sign the sentencing paper.
2 things. If you catch new charges before I sign the sentencing, or it comes time to report to probation and you don't report to probation, because that's going to be the wrinkle, is how Mr. Anderson knows when to report to probation, because he'll have 72 hours from the time I enter the sentences. And he won't know that if, let's just say it takes 2 weeks to iron out the restitution. I don't know how he's going to know that.
When he was arrested on the warrant for this case, he had a nickelback marijuana on. He was questioning whether that would affect this. And my instruction to him was that since it did not occur after any release that would happen now, it wouldn't affect it.
No. What I have in mind, Mr. Anderson, is if whatever it is, if something happens, the date of that bad conduct would be after today. So June 17th, 2020 onward, you get in trouble, whether it's marijuana, breaking into storage units, or hijacking an airplane. That's a problem for these cases. But if it's something that happened before today, you're gonna have to deal with it, but it will not affect your first offender situation.
Okay, just wanted to be clear.
Appreciate it. How are we gonna manage getting Mr. Anderson to probation in a timely way if he gets a signature bond?
I have no problem giving myself one number and making sure that I have the contact information of several people in his family. So once you inform me that he has, signed, or better yet, I mean, we're gonna wait for the restitution stuff to be solidified, maybe do that at a hearing, have him come back.
Because he would be on bond, that's easy to do. It doesn't require getting the sheriff to bring someone over. How long do you think it'll take, Ms. Hall? I guess if it's gonna take 2 days, this is less of a deal, but I wanna make sure you've got the time you need to figure out to whom the individual amounts of restitution go.
The only issue that, the only thing I was waiting on is the 20,000 from the second case. And those victims told us all that earlier today, that it'll take a couple of days.
Okay,
Remember, they have those receipts inside of a file cabinet at their home. So just the end of this week, maybe.
Okay.
We'll have that 20,000. The rest is already attached. I'll just make a copy and email that to Ms. Nelson and Ms. Crawford.
okay, as long as it is easy to decipher. If you're emailing them 80 pages, then I'll ask you to summarize it.
So it's literally one page. It has 10 different boxes. It's like Excel type of breakdown.
Okay.
The things that were stolen and the amount.
Okay, great.
I have the one from the first case, I looked at that.
Yeah, that's what I'm talking about, the first case. I'm talking about the 20,000 is the one where they got. Yeah.
Okay, so what you just held up, Mr. Franklin, should be about $22,000 worth of restitution. And we just need to get the remainder for, and to be clear, I just want to make sure we're not over counting. It would be for Mr. Anderson, it is only Paul Berg and Jeffrey Jackson, whatever was taken from them. Mr. Anderson is not charged in counts 3 or 4. So if it's Eric Henning who had the hunting rifle worth $10,000, he certainly needs to get restitution, but that doesn't come from Mr. Anderson.
Right, no, the two were counts 1 and 2.
1 and 2. Okay, great. I just didn't want us to, if we didn't need to wait on that information, we shouldn't wait. So what I'll do, Ms. Nelson and I will get bonds signed today for Mr. Anderson. That should get you out by tomorrow, Mr. Anderson, but you won't be under sentence yet. So be good. I mean, be good after you're under sentence as well. And then you need to share with Mr. Franklin the most reliable contacts you have, whether it's brother or mother, folks who will answer their phone or their voicemail box isn't full, so that Mr. Franklin can let you know, all right, you now have 48 hours to show up at probation. He'll tell you where you need to go. You'll show up, you'll have that great driver's license, and you'll be able to show them who you are, and they'll get you set up. All right, Ms. Hall, anything else in connection with Mr. Anderson's case? You'll get, as soon as you get the restitution information through Ms. Rolak, you'll get it to Mr. Franklin. Okay. Mr. Franklin, anything else for Mr. Anderson?
No, sir.
All right. And the Judge LaGrua case, I don't know if it's been officially transferred to us, but it would be green sheeted here anyway if it hasn't come to us. So the 786 case.
I thought it was, but
Okay, I'll work with Ms. Nelson on that. I think that's it. Mr. Anderson, you have any questions?
and say thank you,
Thank me by getting back with UPS and staying away from red. All right. Thanks.
Judge,
Yes.
I would need to get Mr. Anderson's information from his attorney. You can have them step to the side and I can talk to them via chat, or I can call and get his address so that I can give him his report instructions.
So hold on one second, Mr. Anderson. Right, so I knew you needed to do that. I'm not signing the final disposition today. We're waiting to get restitution info. But Mr. Anderson's right here. He can hear you if you want to tell him that information, that once he gets word through his lawyer that he's been sentenced, then he needs to do what you tell him. Will that satisfy what you need to do?
Sure, you can just have his attorney get his address, and once the attorney can give it to me, and I will tell him what department he needs. If he lives in Fulton County, he can report to the Fulton County office, or depending on what county he's in.
Well, let's just get it
That
right
will
now.
work.
Mr. Anderson, where will you be living? What's the address? And where's that? Yeah, he'll be living in Fulton County, right off of MLK.
Okay, so I'll give him the report instructions after you sign it, and once he's been sentenced, and I'll just go ahead and give it to the attorney.
You'll get it to Mr. Franklin.
Yes, sir.
Okay, sounds like a plan. Thank you.
Okay, thank you.
All right. Thank you, Mr. Forte. We can go off the record. All right, so Ms. Hodge and Ms. Rolak, Ms. Nelson, you guys are all still on. Ms. Crawford, please stay on for a sec. I just want to chat real briefly about how this worked or didn't work. I'll say up front, clearly the biggest obstacle I see is that we don't have a bridge yet between folks who are in court and folks who are on Zoom. So if Ms. Hall was talking, the only way you could hear her is if it got grabbed by the microphone on my computer, which isn't turned towards her. So it's hard to hear or impossible to hear what's going on in court. Our IT team is working on that. Beyond that, were there issues, Ms. Hodge, that you had with things?
No, Your Honor, that was the only issue. I just couldn't hear what was going on in court.
Okay.